James?
Yeah, are you Mr. Rim?
Please, Adam. Good to meet you. Have a seat. Can I get you something?
No, I'm good.
You don't have to be so nervous.
Yeah, to be honest, I don't really care for lawyers.
You just met me. Give me a chance. Come on, get some coffee.
Okay.
Excuse me, one more coffee? All right, well, as you know, I'm here through VLS, the Volunteer Legal Services Program of Central Texas. And like a lot of attorneys around town, I donate some of my time to help out folks who have legal issues, but they don't have a lot of money.
Yeah, well, I mean, like, I'm not in trouble now, but, you know.
You just got out of jail, right?
Yeah, and I just kind of want to know what's next.
Well, that's what I'm here to help on. And in fact, I was kind of glad you called because we've been working on this new project to help people like you getting out of prison. Have you heard of Austin Reentry?
No.
It's a program by the Austin Young Lawyers Association. We put together information, booklets, for folks who are getting out of jail and trying to re-enter society, as we call it. And we are trying to help out folks that are trying to get their lives back on track. I think you said you had a few friends who may also have questions.
Yeah, they should be on their way.
All right, good. Because we actually have some videos we've been putting together that might help.
Okay, hold on. I don't really want to just see a video of a pretty boy lawyer in front of a building, talking blah, 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 whatever. I mean, I've heard enough legal speak to last me quite a long time.
Fair enough. So what's your first question?
Well, I mean, first of all, I have a record now. And so I just want to know if it's going to come off in a few years or ever.
No, I think you're talking about expunction. You see, if after your trial you're actually acquitted, then you'll be eligible for an application of automatic expunction within 30 days of the date of the acquittal.
Yeah, I caught like every third word you said.
Sorry about that. Let's see, maybe we can take it a little different angle on that then.
Thanks.
Look, I'm not trying to eavesdrop here, but...
No, go ahead.
Since you're answering questions, I'd love to know what's going on with my daughter's juvenile record.
Y'all clearly have a lot of good questions. I mean, what I'm hearing you say is, what's up with my record?
Exactly.
Well, you know what? I have a couple of friends who did the first video, Dave and Ellie, and I think it'll be really helpful. Just take a look at it and tell me what you think.
When you apply for a job, for school, or for housing, you should expect a background check. Now, it's important that you know that these checks can directly impact your ability to get that job, license or degree, or apartment. But it's also just as important that you know that about 1 in 5 adults in the country have some sort of criminal record that will show up on a background check.
And this even pertains to arrest records, even if you weren't convicted of anything. 36 states, including Texas, allow all public and private employers and job licensing agencies to ask about and to make decisions based on your arrest record, even if those arrests didn't lead to any convictions. This means that you could have problems getting a job or getting a license to do a certain type of job just because you were arrested and not convicted. Now, federal law says that local housing agencies can prevent people from criminal records from living in public housing or from getting federal housing assistance. And once again, that criminal record can just consist of an arrest that didn't lead to a conviction, but it can cause problems for you. While this may not seem fair, this is the law, and it's a problem you will have to deal with.
So here's the deal. By law, DPS is required to keep all information regarding arrests, prosecution, and outcomes of all cases except for Class C misdemeanors. And sometimes even Class C misdemeanors are searchable. So what that means is if you've been arrested for a crime that's a Class A or B misdemeanor or a felony, you have a searchable criminal record that can be viewed by anyone who's able to run a criminal records check. The good news is there may be a way around it. It is possible that you can have some or all of those records erased.
An arrest record can cause problems for you, even if it turns out that you didn't do anything wrong. Fortunately, it is possible to get your arrest record erased from all local, state, and federal databases by getting an order of expunction. This order erases all records of the arrest, including information about your booking and your court proceedings.
If you get that order, it's against the law for anyone to use the erased record or file for any purpose. So when can you get it? You can get an order of expunction if your case is dismissed, and that includes deferred prosecution. You can get it if you're not prosecuted after the arrest, if the charge is a Class C misdemeanor and you receive a deferred disposition, if you're found not guilty at trial, or if the governor issues a pardon.
The advantage of having an arrest or criminal offense expunged is that you can legally deny either of those on job applications, as well as for most other purposes. Once an offense is expunged, it will not appear in a criminal record search.
So how do you get an order of expunction? Well, if you're found not guilty, you have 30 days from the date that you are acquitted to apply for an automatic expunction. And if you're pardoned by the governor, you get the expunction right away. If the crime against you is dismissed or not prosecuted, there's what's called a statute of limitations. This is a deadline after which the prosecution can never bring that same charge against you. For most crimes, the statute of limitations is usually 2 to 3 years. Some crimes, on the other hand, have no statute of limitations, and that means there's no deadline for them to bring prosecution. If there's no deadline, you can never apply for the expunction. If you think you may be eligible for an expunction, you should see an attorney about what to do next.
Now, the situation is different if you have been on and completed deferred adjudication probation. In this case, you will not be eligible for an expunction. However, you may be eligible for an order of nondisclosure. Now, this order of nondisclosure is an order by a judge that directs law enforcement to not disclose your criminal records associated with the arrest and the prosecution that resulted in your deferred adjudication. They can't be disclosed to anyone outside of law enforcement. Once you complete your deferred adjudication probation and get this order of nondisclosure, you won't even have to tell people you were on probation.
When you have a record expunged, it's like it never happened. All records of and references to the case are completely erased from all public records. But nondisclosure is different. It means the records are still there, but they're sealed, and the government can't tell anyone about the offense. But the record can still be used against you, like in situations if you're arrested again.
Now let's talk about juvenile records. In Texas, a juvenile is someone between the ages of 10 and 16. Depending on the circumstances, a juvenile record may be eligible for sealing. Sealing results in the automatic restriction of access to the juvenile record. So only criminal justice agencies will be able to access your juvenile record before you turn 21. Sealing prevents the destruction or expunction of these records by the juvenile before the juvenile turns 21. So basically what this means is no one but law enforcement will be able to see your juvenile records, but you can't do anything to get them expunged or destroyed until after you turn 21.
Now, the rules for sealing, restricting, destroying, or expunging juvenile records can get really complicated. So if you have a juvenile record, you should see an attorney. However, it is worth noting that Class C citations in juvenile records usually are not covered by the rules for sealing juvenile records. Instead, they're covered by the rules for expunction that we talked about earlier.
If a juvenile record is sealed, your answer to a question regarding juvenile records should be that no records exist. Basically, once your juvenile record is sealed, you are no longer required to even say that you have a juvenile record.
Just know, though, that if you are arrested again and the charge is subject to enhancement with a prior juvenile record, a prosecutor can apply to reopen those sealed juvenile records at any time. And also, if you're convicted or you take a deferred adjudication for a later offense, your sealed juvenile record is no longer restricted access only.